Yeah, good morning, Alan. Good morning, Vanna. So
Good morning.
we've started our session. Thank you for joining. So we'll just wait a minute more before we start the session for all. I think we'd have some more attendees joining in the next couple of minutes. So it's 2:01 p.m. here in Dubai.
It's,
We'll just wait one more minute.
it's 11:01 in the UK, by the way.
Yeah. Yes. So we have guests coming in for this, and my sincere apologies to everybody pushing this session on a weekend, and Saturday is a weekend both in the UAE and UK.
As I mentioned earlier, the UK is into tier 2 lockdown at the moment. So
Yes.
there's some restriction in the UK at the moment.
Yeah, so we are planning for our audience to understand the business immigration process. So once the lockdown is sorted out, they can accordingly plan. As we will explain today, yes, under your guidance. So here we go. We start. A very good morning to our speakers from UK, and a good afternoon to our guests from the UAE, from India, and the other eastern part of the world. Century Maxim, it is a pleasure for us hosting this webinar today for our guests, which is in collaboration with UCAS, UK Advisory Services, which is a UK-based, London-based company entity providing services on general business advisories. And on behalf of UCAS, we have Miss Vandana, who's a lawyer and managing director of Davenport Solicitors, a UK-based firm providing end-to-end immigration and employment matter solutions. Vandana advises employees and employers on a range of employment laws and business immigration matters, from implementing employment contracts, policies, advising on sponsorship licenses, and managing them. Vandana also advises entities on Tier 1 and Tier 2 visas to represent at the employment tribunal. Mr. Alan Raja has joined us from Lawrence Grant. Mr. Alan Raja is partner at Lawrence Grant since 2001 and joined Lawrence Grant in 1994. Alan has got an experience of 25 years involved in practices in various areas of advisory, which includes valuation of business, due diligence, mergers, acquisitions. Alan is also a specialist on tax matters, advising on various tax applicabilities in the UK and compliances with respect to various businesses, with a specialist understanding on compliances related to medical businesses in the UK. About our firm, we are Century Maxim International, a team of lawyers based out of UAE, providing legal and consultancy advisory services to our clients. We advise on areas related to law, which includes business immigrations, compliance management, contract management, corporate governance, laws and rules and regulations related to financial and capital markets. We do a lot of litigation management with lawyers, law firms, across jurisdictions. We advise companies, entities on IPR and trademarks, and also, today we are doing this session in collaboration with UCAS, with the support of Davenport Solicitors, with the support of Lawrence Grant, on investments in businesses across territories. And our topic today is for business immigrations to UK. UCAS, I would just want to give a brief. UCAS is an end-to-end market and strategy and services firm which provides services including business and tax matters, business strategies, business immigration, human resources, legal and regulatory requirements, market entry, relocation, and related services. So we'll quickly start our presentation today. So welcome all for our webinar on investments and businesses across territories. So as I mentioned, the webinar is being hosted by Century Maxim International in collaboration with UCAS. These are our practice areas, which is business immigration, contract, compliance, etc. And in our web session today, we discuss business immigration and investments in the UK. About our speakers, Vandana, Managing Partner, Davenport, Mr. Alan Raja, and myself, I'm Farhad Ali Khan, Managing Partner, Century Maxim International, a UAE-based firm. In this webinar, we will be covering the following points, which is one, business immigration to UK, business entity structures that could be formed when you enter doing business in the UK, what kind of companies can be formed, what is the immigration and types of visas that are applicable for conducting businesses in the UK, a basic of UK employment law, what are the applicable taxes in UK, and are there any tax allowances in UK? So I would be explaining the following points. What is business immigration, types of business vehicles, first steps for business immigrations, immigration of business owners and representatives, and how CMI would be assisting companies in the UAE and other territories when it comes to business immigration, when it comes to moving and expanding businesses out of UAE or your origin country to UK and from UK to the other parts of the world. So before I start my slides, I would just like to mention here what Muhammad Yunus in 2006 said. He's a Nobel Peace Prize winner and founder of Grameen Bank of Bangladesh. He said, I support globalization as it benefits the poor. Globalization is like a 100-lane highway crisscrossing the world. And if there are no traffic rules, then all the lanes would be taken over by giant trucks of powerful economies of the world. Why this is important to mention here is because I feel that both UAE and UK are destinations which have citizens and people of origin from across the world doing businesses, practicing professional activities, living and staying and conducting activities here. So these two destinations could be so well connected for businesses that it would the real meaning of globalization could come out of these two destinations. So what is business immigration? So I would like to explain business immigration as a process, which involves a number of activities, number of steps to be taken. It requires submission of a business plan to set up business activity in the UK. So what would be your business plan? Are you entering into food business? Are you entering into health business? Are you, you would want to get into some kind of a manufacturing of any items or electronics or service related? So there has to be a business plan. Now, once you have a business plan, it requires incorporation of an entity which would allow you to extend your business in this new territory. So if you're taking your business out of India, out of UAE or any other country to the UK, so one, there has to be a business plan, and this business plan would have to be fit into a legal entity. Which legal entity could be a foreign branch of your existing company, it could be a subsidiary, it could be a share acquisition or some kind of a strategic investment or a financial investment. Now, when you have the first three steps taken, obviously there would be requirement of a person that you can depend on conducting and monitoring these activities. The person is called the director or your representative or a general manager or a sole representative in the UK, representing you, your company or your business interest for expanding the businesses out of UK and to other jurisdictions. Now, as you conduct these activities, it also requires certain regulatory approvals. Now, every business in this world requires a regulatory approval. A food business would require approval from the food authority. A health business would require approval from the medical or the health authority. Construction business would require approval from various other authorities, which could be the municipality, which could be the land department, which could be fire department, and various others. Now, when you have all these activities structured, it completes a business immigration process would complete only once employees are onboarded under formal employment contracts. So once these steps are completed, it is called the process of business immigration. In the UK, you can have various types of structures. As I just mentioned here, it could be a subsidiary, it could be a branch of your existing UAE company or your origin country, which can be incorporated in the UK. It could be some kind of a strategic investment by holding shares or becoming a financial investor through an SPV. These structures are very important to be, to be considered while having businesses to be moved to UK and elsewhere. Now, in the UK, companies could be formed under the UK Companies Act of 2006, and there are different types of companies which can be formed. Which it could be a private, a public company, which is under Section 4 of the UK Companies Act. A private company can be managed by by a set of individuals privately. However, a public company is where investments are taken by public at large. Companies could be formed which could be limited by guarantee or having a share capital. Interestingly, there's one more thing. Companies can be formed for charitable purposes. So suppose you are working for an organization which is doing a lot of charitable activities and engaged in a not-for-profit objective. So the same company could be taken to UK under the community interest companies as per provisions of Section 6. So, the first steps for business immigration is check if it's legal for you to start your business in UK. So I always say that, a lot of countries, they have embargoes, they have trade restrictions, they have restrictions under the General Agreement of Trade and Tariffs. Say, for example, a country which would be the largest exporter of coffee, they would not allow generally companies engaged into the business of coffee elsewhere to bring and import coffees from outside of their country, because it disturbs the local economy. So number one, we need to check if the business that you plan to do in UK, are there any trade restrictions? Is it prohibited to conduct similar kind of business in the UK? So what is your business plan? What is your business name? We need to follows if first we check if there are no trade restrictions. Prepare a business legal structure, type of company, etc. Appoint directors or key representatives. Form a memorandum of association and articles to be incorporated, to be written, framed, and signed by all the shareholders. And then go for licenses and regulatory requirements for your businesses in the UK. Now, in certain situations, we also see that immigration of business owners and representatives is also very important. So somebody is into the business of dairy or whatever products, and he would want to set up a similar activity in the UK. Now, this could be a business which may require specialists who have been with the company for years and could be asked to move to UK. So understand the structure of business, what management controls and who would manage these controls in the UK. So a promoter or a director or a sole representatives may be required to relocate to UK to conduct these activities. And under the UK immigration laws, this is permissible. Now, how do CMI provides assistance to companies in origin countries? So suppose you are a company in the UAE or other territories where you would want to conduct your business activities in UK. We understand your business structure. We will do a research whether you can take your business forward to UK, whether it is permissible for you to conduct similar kind of business activities in the UK. We would then advise you what type of investment structure you should be having. If it should be a holding company, if it should be a midco, if it should be an operating company or a subsidiary or a branch, or it could be a strategic investment. Where will your brand be placed? How will you have control on your brand ownership? So your brand could be of equal value to what your physical assets of the company be. And in the cases of companies which are only into service, there may not be any physical assets, but only brand. So how would your brand be protected? Who controls your brand? We advise you on that. Management controls, entering into JVs, documents are very important to be reviewed by professionals. So we advise you on that as well. And finally, we review the complete set of documents that are required for a company to have its businesses moved from UAE or from their origin countries to the UK. Now, and CMI assistance to companies for UK. So once you have planned everything, how would we be able to assist you? We do a full due diligence. Due diligence is something very important for companies entering into any market. Say, for example, a company would be required to enter into food business or health business. So give us your business plan. We will understand and seek consultation of lawyers from UK, do a research on that and submit it for your review, that whether this business is permitted, what are the legal requirements for conducting this business. So it's a legal due diligence where we assist you with all the basic rules and regulations that could be applicable for you to conduct your business. We assist on submission of KYC and profile documents. That is very important for business entities and owners when they move to UK. If there are any trade agreements between countries, we do a research on that and advise our clients. And we liaise with our UK lawyers, law firms on matters related to immigration, employment, investments, etc. We also liaise with our UK advisors, which is UCAS, and on various tax matters on setting up businesses and tax implications. And what tax implications could be there? Because UK, it's a taxable jurisdiction. So this is it. So thank you for bearing with me. Vandana, please, if you can explain our audience here on the types of visas, how migrant workers can move to UK, and what employment laws are applicable in the UK. So Vandana, Managing Director of Davenport Solicitors, will take it forward.
Thank you, Farhat. So today I'm going to be focusing on three particular visas, which is the Startup, the Innovator Visa, and the Representative Overseas Business Visa. I'm going to look at how you could employ migrant workers to the UK and touch upon the employment law in the UK and what is required initially when you set up your business in the UK. So firstly, on the Startup Visa, you can apply for a startup visa if you want to set up in the UK, set up a business in the UK, and you're from outside the EEA and Switzerland. You must be, however, endorsed by an authorised body that is either a UK higher education institution or a business organisation with a history of supporting entrepreneurs. You must be able to show that your business idea is new. It has to be a new, innovative idea, and you cannot join or invest in a business that is already trading. The business idea must be original, which is different to anything else on the market. And it has to have the viability and the potential for growth in the UK. You should only approach those endorsing bodies that are relevant and suitable to your business idea. How much you pay for the startup visa in relation to the Home Office visa is very dependent on your situation, but it is approximately £363 if you apply from outside the UK. You will also have to pay the health surcharge, which is £400 per year for all other visa and immigration applications. With this particular visa, you can stay in the UK for 2 years, but you cannot apply to extend this visa. If the visa is cut short, if the endorsement is cut short, then you will need to apply for a new endorsement if you want to continue to stay in the UK for longer. With this visa, you can bring your family members, your dependents with you to live in the UK, and you can switch to this visa from some other visa categories. You can also work in another job as well as working for your business, but you cannot get public funds, recourse to public funds, or work as a doctor or dentist in training, work as a professional sportsman such as a coach, or settle in the UK on this particular visa. It is a requirement that you must be at least 18 years old and you have to meet the English language requirement. You must also be able to show that you have enough personal savings to support yourself whilst in the UK. And that's at least, you need to show at least £945 in your bank account for 90 consecutive days before you apply. The English language requirement test requirement can be fulfilled if you can pass a approved English language test with at least a CEFR level B2 in reading, writing, speaking and listening. Or you can have an academic qualification which has been taught in English and approved by an organisation called UK NARIC. I've put this link here so that you can either Google it or click on this link to get access to the endorsing bodies that are available for you to approach if you decide that this is a visa which may be appropriate for you to come to the UK and start a business. Now, moving on to the innovator visa, which is similar to the startup visa, but does have some differences. So you can apply for this particular visa if you want to set up and run a business in the UK. You must be outside the EEA and Switzerland, and you must have £50,000 in investment sums to invest. Your business or business idea must be endorsed by an approved body, and that approved body, there's a list available on the link that I had shown you on the previous slide. You must have at least £50,000 in investment funds if you want to set up a new business. You do not need funds if either your business is already established and has been endorsed for an earlier visa, or you've changed your business and already agreed it with your endorsing body. You must be able to show, like the startup visa, that the business idea is new and you cannot join or invest in a business that is already trading in the UK. The idea must be innovative, and so it must be new and something which is not already in the UK market. In terms of fees, the fees are approximately £1,021 to apply for this particular visa. And again, you may need to prove your knowledge of the English language when you apply for this visa. You can apply, or you can form a team with other innovative applicants, but you cannot share the same investment funds. Your team must have £50,000 per applicant. So if you have two, then there must be £100,000 which needs to be invested. With this visa, you can stay in the UK for 3 years, and you can switch to this visa from another visa. You can also apply to extend for another 3 years when your visa is due to expire, and there's no limit on the number of times you can extend this visa. You may be able to apply for settlement, also known as indefinite leave to remain, once you've been in the UK for 3 years. Like the startup visa, your visa may be cut short if your endorsement is withdrawn. And if you want to stay longer, then you must apply for a new endorsement before your current visa expires. With this visa, you can set up a business or several businesses, work for your business, which includes working as a director or self-employed or a member of a business partnership. Before you apply, you need to have your business or business idea assessed by an approved body, and they will provide you with an endorsement letter if your business is viable. You must also be able to show that you are at least 18 years old. You may need to show that you meet the English language requirement, and you must be able to prove that you have enough personal savings to support yourself in the UK, and the same limit applies as the startup visa. Now, moving on to the sole representative visa. This is quite a popular visa, and you can apply to the UK as a representative of an overseas business if you're from outside the EEA or Switzerland, and you're either the sole representative of an overseas business planning to set either a UK branch or a wholly owned subsidiary, or an employee of an overseas newspaper, news agency, or broadcasting organisation, posted on a long-term assignment to the UK. A representative of an overseas visa costs approximately £610, and you will also need to pay the health surcharge when you apply for this visa. If the application is successful, then you can come to the UK for an initial period of 3 years, and you may be able to apply to extend for another 2 years. Once you've completed 5 years, then you'll be able to apply for settlement, also known, as I mentioned, indefinite leave to remain. With this visa, however, you have to work for your employer full-time. You can bring your family members, which are your dependents, with you to live in the UK. You can also apply to extend this visa once you're in the UK, and as I mentioned, apply for indefinite leave once you've reached 5 years. If you're coming into the UK as a sole representative, you must be recruited and employed outside of the UK by an active and trading business whose headquarters and principal business is outside the UK and will remain outside the UK. You must have the skills, experience, and knowledge to do that role and hold a senior position within the business, but do not own or control the majority of it. And you must have full authority to make decisions on its behalf, and intend to establish the overseas first commercial presence in the UK, either as a registered branch or a wholly owned subsidiary. There are various documents that you need to supply with your application, along with mandatory documents such as your passport and evidence that you can support yourself and your dependents when in the UK. You must be able to show that you meet the English language requirement. You might need to provide results of your TB test. You must also submit any translations of any documents which are not in English. When applying for the sole representative visa of an overseas business, you'll also need to provide a full description of the business activities, including details of assets and accounts. A letter confirming the overseas business will set up a wholly owned subsidiary or a registrar branch in the UK in the same business activity as it runs overseas. Your job description, employment contract, and salary details, and a letter confirming you're familiar with the business and have the power to take operational decisions. You should also provide evidence that you are directly employed by the business and not acting as a sales agent. You must show that you hold a senior position in the business with your authority to bind the organization and make decisions on its behalf, and you'll be working full-time for the business or subsidiary for the duration of your stay and will not carry out any other work. You must also show that you do not hold or control the majority of the overseas business. Once you're in the UK, your application has been successful. You may then consider looking at whether you can bring overseas talent, and this may be from your overseas business. So it's important to understand how you can become a sponsor. In the UK, you need to be a sponsor to be able to recruit overseas migrant workers. The points-based system currently only applies to migrants outside the EEA and Switzerland, and the UK government has indicated that the points-based system will be extended to EEA and Swiss nationals with modifications from the 1st of January 2021 as a result of Brexit. So ultimately, non-EEA nationals as well as EEA nationals will need to be sponsored by a UK employer who holds a sponsorship license in order for them to enter and work and remain in the UK. So if the organisation decides that they do want to apply for a sponsorship license, how do they do that? To obtain a sponsor license, employers have to apply online through the Home Office's website, and they must supply the relevant documentation that is requested by the Home Office. The Home Office will check whether the organisation is suitable. They will check if the organisation has effective human resources systems in place, whether the sponsor duties can be complied with, whether the organisation can offer genuine vacancy, and whether the director has any unspent criminal convictions. The Tier 2 and Tier 5 points-based system are the primary immigration routes for migrant workers who want to work in the UK. And as mentioned, these migrant workers must be sponsored by a UK organisation that holds a sponsor licence before they are able to work in the UK. So as I mentioned, the primary categories are the Tier 2 and the Tier 5. The Tier 2, there's two types of Tier 2s. There's the ICT visa and the general visa. The Tier 2 ICT visa is for those overseas employers who have offered a role to the employee in the UK branch of the organisation, whereas the Tier 2 General is for skilled non-EEA and non-Swiss nationals who want to come to the UK to work, but they must have a certificate of sponsor from a UK employer. There is the ISC, which needs to be paid when making the application, and that's currently £364 for 12 months and £182 for each additional 6 months for small or charitable sponsors. So how do you apply for a sponsorship license? As I mentioned, there is an application online that needs to be submitted and the fees that need to be paid. Currently £536 for a small or charitable sponsor and £1,476 for a medium or large sponsor. Once the application is submitted online, the employer will need to submit the supporting documents along with the submission sheet, which could be downloaded after the application has been submitted online, and it has to be sent to the Home Office within 5 working days, along with the supporting documents. The decision can take up to 8 weeks, but generally speaking, most applications are decided within 4 weeks. The Home Office may want to do any pre-compliance visits, and some of these visits can be arranged, and some are not arranged, and so the Home Office Compliance Office can turn up at the organisation without any warnings. So it's important that organisations have the correct HR systems in place and be able to show that they are able to comply with the sponsor obligations. The documents required vary, but if you're applying for a Tier 2 and Tier 5 categories, then you also need to provide a document which states what the opening and operating hours are for the organisation. A hierarchy chart or organisation chart will need to be submitted. And if your business has 50 employees or fewer, you must list all employees and set out the names and titles of the staff members. You must also provide information about the job, and the job description must include the job title and the SOC code. Now the SOC code is you can check it on Google as well. If you just type SOC code in the UK, you can come up with a whole list of the SOC codes which apply to the job titles. You also need to state what the duties are and where the job sits in the hierarchy chart. You also need to mention the minimum salary that you will guarantee for the job if it was available. There are a range of documents that you can choose from and that you can provide in support of your application, but they must be originals or certified copies. With certification, it must be certified by a lawyer. Some of the documents I advise my clients to submit, which are easily accessible, are documents from HMRC, which confirm PAYE and VAT registration, the lease of the premises, bank statements can also be provided, and an employer's liability certificate. Complying with your obligations. From January 20 to the 1st of January 2021, freedom of movement between the UK and EU will end, and the UK will introduce an immigration system that will treat all applicants equally, regardless of where they come from. Anyone you want to recruit from outside the UK, excluding Irish citizens, will need to apply for permission first. You need to ensure that as an employer, as a sponsor, you're able to comply with your obligation. This includes reporting duties if your migrants leave or do not turn up to work. From the 1st of January 2021, anyone you recruit from outside the UK for the skilled worker route will need to demonstrate that they have a job offer from a Home Office licensed sponsor, they speak English at the required level, the job offer is at the skill level of RQ F3 or above, which is equivalent to A level and not degree level as is at the moment. They will be paid at least 25,600 or the going rate for the job offer, which is higher. Currently, it's 30,000 for most jobs. If the job will pay less than this, but no less than 20,480, the applicant may still be able to apply by trading points on specific characteristics against their salary. In the UK, when you set up, you may think about taking on your first employee, someone to run the organisation. And if so, you need to be able to understand what the minimum basic employment law requirements are. So setting up a business in a different jurisdiction can be a daunting process. And it is important that you understand there are several types of employment relationships in the UK. However, if you're engaging people to work for you, they are very likely to be workers or employees unless they are clearly self-employed. As soon as you become an employer in the UK, it's advisable to have employer's liability insurance from an authorised insurer. The insurer will help you. The insurance will help you should you need to pay compensation if an employee is injured or becomes ill because of work they do for you. You should also note that in the UK, there's an annual leave minimum requirement of giving to you, which needs to be given to your employees, which is 20 days plus 8 days holiday, which includes public bank holidays. There is a statutory notice that needs to be provided if you decide to terminate your employee's contract. Currently in the UK, if you want to terminate an employee's contract, you must give the minimum notice, which is 1 week's notice if employed for 1 month or more, up to 2 years. And after 2 years, a week's notice for every year that they're employed, up to a maximum of 12 weeks. There is a minimum wage that needs to be paid to employees in the UK, which is £8.72 for those who are 25 years or older. And an employment contract setting out the terms must be provided to all UK employees on the first day that they start employment. So thank you very much for listening, and I'm going to pass it back on to Farhat. Farhat, you're muted.
Yeah, thank you. Sorry, I was on mute. Thank you, Vanna. This was very insightful, very well explained the different aspects of obtaining a visa to UK, the different tiers of employment visas, what minimum salaries are required, what minimum number of leave an employee would be entitled to, how an employee could be terminated, how the employment contracts could be formalized in the UK. I would now request Alan, who's a partner with Lawrence Grant, a firm which, Alan provides advisory services on tax and compliance matters. Alan's client portfolio includes both local UK and international clients, focusing on strategic analysis and business development. Alan, please, if you can take this forward.
Thank you, Farhat, for the introduction. As Farhat mentioned, I've been in practice for over 25 years. And I've been advising personal and corporate clients on steps they should be taking before setting up business or relocating to the UK. I'm going to go through the next slide. So I'm going to discuss the regulatory requirements in setting up a business in the UK. There are different types of businesses in the UK, and you could trade as a sole trader, a partnership, a limited liability partnership, also known as LLP, and also a limited company. I'll go through each of the possible options in the next slides. In order to set up as a sole trader, you'll need to register with HMRC, also known as Her Majesty Revenue and Customs. And depending on the type of business, you'll need to register for VAT tax, also known as VAT. The VAT registration limit in the UK is £85,000 per annum. What this means is that if your turnover is over £85,000 on a rolling 12-month basis, you'll be obliged to register for VAT. You also need to complete accounts and tax returns every year. Any tax due and payable will be due on 31st January each year. In order to establish a partnership, you must have more than one member. You also need to register with HMRC. Again, depending on the type of business, you'll need to register for VAT. Some businesses, such as medical practices and financial institutions, are exempt from VAT registration. You also need to complete partnership accounts and tax returns every year. The tax liability is on the individual and not the partnership itself. The individual will need to pay tax on 31st January each year. In order to set up a limited liability partnership, which is also known as an LLP, you must have more than one member, and the second member could be a corporate member. The LLP will need to register with Company House and HMRC. Again, depending on type of business, you'll need to register for value-added tax. As a sole trader and simple partnership, the LLP will need to complete accounts and tax returns every year. The main difference between LLP is that you'll need to submit accounts to Company House and HMRC. The tax liability is on the individual and not the LLP itself. The members of the LLP will need to pay tax due on 31st January each year. An important tax planning tip for an LLP is that if all your trading income and members are outside the UK, there'll be no tax payable in the UK. In order to set up a limited company, you'll need a minimum of one director and one shareholder. The director and shareholder can be outside the UK. You also need to register the company with Company House and HMRC. Again, depending on the type of business, you'll need to register for value-added tax. The director will need to complete accounts and tax return every year and will need to submit these to the Company House and also HMRC. The tax liability is payable by the company, and the company will need to pay tax within 9 months of the year end. There are a number of tax planning opportunities in setting up a company, and that includes no withholding tax on dividends declared by your UK company. And if the UK company is a holding company, and it'll be exempt from capital gains tax if the subsidiary is sold either in the UK or abroad. Lawrence Grant will be able to assist you in setting up an onshore and offshore tax planning solution by using UK limited companies. The most popular choice in setting up a business in the UK is by far by incorporating a company in the UK. I'll briefly discuss the incorporation process in the UK, as well as the tax implication in the UK. A UK company can be set up within 24 hours of receiving the due diligence documents. You can use Lawrence Grant office as a registered office. Like most countries around the world, the biggest challenge is the opening of the bank account in the UK. And we all know how difficult it is to open bank accounts around the world. We're also able to provide a nominee director and shareholder services to meet the compliance requirements in the UK. There are a number of taxes payable in the UK, and I'll briefly discuss each of these taxes. Corporation tax is payable by companies, and the current rate is 19%. The corporation tax is payable 9 months after the year end, and you'll need to file your account and tax return with HMRC within 12 months after the year end. The VAT rate for most businesses in the UK is 20%. Due to COVID-19, the government has introduced a 5% VAT rate for the hospitality, hotel, and holiday industry. The 5% VAT rate will be in place until 12 January 2021. Some goods and services, such as home energy, is charged at 5%. And there's also a zero rate for goods and services such as food and children's clothing. You'll need to complete a monthly, quarterly VAT return, and that depends on your requirements. You also need to file and pay your VAT liability 1 month and 7 days after the monthly or quarterly VAT period. Inheritance tax, also known as debt duties, is taxed at 40% on an individual's estate. Their tax-free allowances are up to £1 million before the 40% is applied, but the allowances will not apply to everyone. Foreigners will also be subject to inheritance tax for assets held in the UK. Moving on to payroll taxes, if you employ staff in the UK, you'll need to account for payroll taxes, and this includes employee national insurance contribution, where the tax is up to 12% on gross salary. The employee national insurance contributions is taxable at 13.8% on gross salary. Pay as you earn, also known as PAY taxes, range from 20% to 40%. The taxes are payable 22 days after the month end. I'm going to spend a bit more time on capital gains tax. So if you buy and sell fixed assets in the UK, you'll need to pay capital gains tax, also known as CGT, on the gain that you make. CGT only applies to individuals, while companies pay corporation tax on any gain they make. For individuals, any gain on sale of assets, except residential properties, will be subject to 10% or 20% tax. This is dependent on the individual's lower rate or higher rate taxpayer. If you make a gain on residential properties, the tax rate is higher, which is 18% or 28%. Since April 2015, capital gain tax applies to foreigners who make gains or sale or on gifting of residential property in the UK. HMRC currently uses a very powerful software called Connect software that is able to identify foreigners who own assets in the UK. A couple of weeks ago, I had a call from one of my clients who informed me that her parents who reside in Singapore received a letter from HMRC inquiring if they paid any tax on the property they sold in the UK 3 years ago. The background of this basically was that the parents purchased the property with my client in 2007 for my client to live in while she was studying in the UK. This was before the rules changed in 2015, and we're now working on the potential capital gains tax penalties and interest for non-disclosure. I'm sure some of our viewers today have residential properties in the UK and will urge you to seek professional advice to mitigate any potential taxes in the future. Moving on to annual tax on envelope billings, also known as ATED, is payable on residential properties that are owned by UK companies or offshore structures. The ATED tax is payable depending on the value of the property. The tax payable ranges from £3,700 to £236,000 per annum. The ATED tax payable applies to residential properties over the value of £500,000. And the ATED tax is payable every year. Stamp duty land tax, also known as SDLT, applies to purchase of properties. The SDLT rate ranges from 5% to 12% on residential properties. An additional 3% stamp duty land tax is payable when you purchase a second residential property. Due to COVID-19, the government introduced an incentive scheme where no SDLT will be payable on properties up to the value of £500,000. The incentive is open until March 2021. The SDLT on non-resident properties range from 1% to 5%. So although the government has introduced a raft of taxes in the UK, there are a number of tax allowances and reliefs available in the UK. For instance, when you purchase fixed assets in the UK, you may be entitled to claim capital allowances. The current annual investment allowance, also known as AIA, is £1 million up to 31st December 2020. The AIA allowance is reduced to £200,000 with effect from 1st January 2021. The writing down allowance, also known as WDA rate, is 18%, and 100% first-year allowances may be available. The government introduced the EIS, or Enterprise Investment Scheme, for individuals to invest in private companies in the UK. You can make a maximum investment of £1 million per annum, and you will also receive income tax relief of 30%. Any gain that you make from the investment will be exempt from capital gains tax if the investment is held for 3 years. Seed Enterprise Investment Scheme, also known as SEIS, is a much more attractive scheme. The maximum investment that the taxpayer can make is £100,000 per annum, and the income tax relief is 50%. Any gains will be exempt from capital gains tax if the investment is held for 3 years. Another tax incentive scheme is the Venture Capital Trust, also known as VCT. The maximum investment you can make is £200,000 per annum, and you receive income tax relief of up to 30%. Any dividend income received will be exempt from tax, and any gains will also be exempt from capital gains tax. The patent box is designed to encourage companies to keep and commercialize intellectual property in the UK. It allows companies to pay a reduced corporation tax of 10%. The next one is the Research and Development Relief, also known as R&D, which supports companies that work on innovative products in science and technology. The relief is provided for up to 230% on expenditure incurred. And you can claim a tax credit if the company makes a loss. I would just conclude on that, you know what, despite Brexit and despite what's happening around the world in terms of COVID-19, the UK is still open for business, and I've just been through some of the allowances that are available for companies and individuals moving and setting up business in the UK. On that note, I'll hand you over to Farhat to show the next slide.
Thank you, Alan. This was excellently explained. Every parameter has been explained in such a fantastic, separate manner the different types of taxes, the different types of benefits, reliefs, opportunities, what business owners, promoters, individuals, can look forward if they would want to invest, move to the UK, expand their businesses to the UK. Really appreciate. I mean, a lot of people, our clients would be interested in knowing, as you mentioned here, that there's no stamp duty tax applicable until March 2021. Just one question that came to my mind, if you can explain this also. This applies to properties purchased by non-UK residents for up to 2021, correct?
That's correct, but there's one caveat there. If you have another property, then there's additional 3% stamp duty on that.
Okay.
So most foreigners will have a property abroad, so the 3% stamp duty will apply on the first half.
So if our clients would want to know, would be interested in purchasing properties in the UK, could your office also assist on providing a due diligence with respect to the properties, with respect to title of the property, any encumbrances on the property? Can that also be?
We can assist you on that, because we do have partners who are in the property business, so we can do that. Excellent.
So I would, as we go next, I would request our attendees here, clients here, if they would be interested in asking any questions, whatever they would want to know with respect to business migrations to UK, any questions they would have in mind, whether they can take their family members, whether they can take their parents, whether they can, sponsor employees, what would be the minimum amount of investments, they may put it here in the chat room, and we'd be more than happy to answer it. The panel is here, the speakers are here, they would we try and answer as much as possible. One question I think we have: at what stage can I apply for UK passport? Vandana, if you can please help us with this answer.
Yeah, so the UK passport is obtaining that there's a process that you need to follow. So you need to be able to first obtain indefinite leave to remain. And as I mentioned, there are some categories of visa which allow you to apply for indefinite leave to remain. So for instance, if you've been on a tier 2 for 5 years, you can apply for indefinite leave to remain. Then you need to go through a process called naturalization, and that's a separate process. And it's after that you can then apply for a British passport.
Okay. Thank you, Vandana. Alan, I have another question here from Ankur. He wants to know, how about due diligence on acquiring a running or a closed business? So what I understand, he would be interested in knowing whether the running or closed business, if it's got any liabilities, if it's got any exposures, if it's got any outstanding employment issues, etc. So can we do a due diligence on businesses which we intend acquiring, which are already running or closed?
Yeah, we've been assisting clients who are looking to acquire business in the UK over a number of years as well. So what we do is we do the financial due diligence, and we work closely with lawyers to look at the other aspects in terms of regulatory requirements. If there's a property involved, we tend to do searches with the land registration to ensure that the property is unencumbered. So we do a full due diligence for clients who are looking to acquire either the shares or the business itself. So there are different aspects in terms of different tax implication, whether you're actually acquiring the business as a share acquisition or as a business itself. So we'll do a full due diligence on that. Yes.
Complete due diligence, including the beneficial owners of the company that may be operating it.
That's correct. That's what we'll do. Absolutely right.
Okay. So Mr. Datta is asking a question with respect to a platform, if he can find an investor in the UK. Okay, so we could take it separately. There's another question: is there a limit on how many family members I can sponsor?
No, there's not a limit, but generally speaking, it's usually your spouse and your children, and the children usually are below the age of 18.
Okay.
They're classed as dependents.
Okay. That's okay. So thank you. I think we'll just wait for a minute if there are more questions coming in. But it's really been very, very insightful, Vandana and Alan. We've got some very good inputs on how businesses could be set up in the UK, what fee structures are applicable. one concept I think we can clear out today to our attendees, that it's not expensive doing businesses in the UK. The fees, the government fees, etc., it's very nominal. And if you can just mention a few lines on this. There's a lot of queries which from our clients that come. They say that UK is a heavily tax structured jurisdiction. So are there benefits also that people can get?
I think I would say the UK compared to the rest of Europe is not so heavily taxed because our corporation tax rate is 19%. We do have a lot of indirect taxes for employees, that's correct. But overall, the business, if you structure it correctly, you're able to minimize the tax that's payable in the UK. As you mentioned earlier, the cost of setting up a UK company is pretty minimal compared to the rest of Europe. In fact, a client just formed a company in Europe, in Australia, for instance, and it's taken a huge long time to open up a company. They've got to do all the compliance requirements. The cost of setting up is extremely onerous as well. Whereas in the UK, it's pretty fast, pretty quick, and everything's available on the website as well. So, in terms of ease of doing business in the UK, I would say it's much more easier. Even the employer's requirement in the UK is less onerous compared to Europe. Europe, they do have a lot of employee rights compared to what we have in the UK. So I think there's still, despite Brexit, we find a lot of clients looking to move from Europe to the UK and setting up business in the UK.
Thank you, Aaron. Wanda, please don't get upset. There's a question here saying that what about the lawyer's fee? What are their fees like? So the guest would want to understand if the lawyers are very expensive in UK or not. I think you're on mute, Padma.
Can you hear me now?
Yeah.
I said, sorry. I said no, they're not. Lawyers' fees are not expensive at all. But it ranges from who you instruct. So if you go to lawyers who are probably based in multinational law firms, they probably are going to be quite expensive. Our fees start from in relation to the visas that we've discussed. Our fees start from around about £3,000, and then depending on the circumstances and the work involved, we then quote what the fees would be. As the applicants would be outside the UK, their VAT would not be applicable to them, so they won't be paying VAT on it.
Thank you, Wanda. One last question I will take, and because so this is a question where an attendee would want to know that what would be the process. Would it be similar to Canada, starting January 2021, which is this new point basis immigration system that is being introduced in the UK?
It's very similar to what we have at the moment. Fair. There's just some, there's going to be some changes, which is going to probably make it easier for overseas nationals to come to the UK. For example, I mentioned the salary threshold, which will be reduced. Currently, it's on around about £30,000 as a minimum, but that for some jobs that is higher. And then you've got the possibility of trading points depending on the sections where you can trade points, and that's a change as well. And also the education requirement. Usually the jobs at the moment have to be at a degree level equivalent, not saying that they must hold a degree, but they have to be degree equivalent. And after the new system comes into place, it will be A-level equivalent. So there's not going to be, in terms of skill level, that will be reduced as well.
Okay, understood. So I think that's it. And before we conclude our session, so let me just read out the disclaimer. So one clear request to all our attendees here, that please do not consider any contents on this presentation. This is the general information. Specific informations could be obtained once you contact us and give us your specific requirement. We would do a research based solution for you and come back to you with an answer. So thank you, Vandana. Thank you, Alan. It was wonderful having you today. A very well explained, insightful process on the immigration to UK. how businesses can be moved and expanded from territories to UK and from through UK to the rest of the world. Thank you very much, Anna.
Thank you so much
for organizing it.
Thank you, Alan, and thank you the entire team of UCAS for supporting us.
Thank you so much.
Thank you.
Take care. Bye-bye.
Right.